Welcome to Advocacy at 8. I am attorney Sandra Jill Poland, your community legal advocate. Advocacy at 8, my new YouTube legal series, launched October 1, 2018. The legal education videos, which make up this series, will be posted daily on YouTube by 8 p.m. Each video in 8 minutes or less will educate you on an important legal issue. You and your community will be enlightened and empowered. Thank you for viewing Advocacy at 8. I am attorney Sandra Jill Poland, your community legal advocate. This week's topic, dying without a will. Is it worth it? What can happen if you die without a will? Does death bring out the best in people? We know it can often bring out the very worst. That is what Anne Brenoff asked in her May 2016 article, which appeared online at HuffPost. The article was written right after Prince's death in April 2016. In Brenoff's article, she reports that about 55% of Americans don't have wills. Most of those people, 60% of that 55%, say it's because they have not gotten around to making one. For African Americans, Brenoff reports that 68% don't have wills. That's almost 7 out of 10. Latinos, 74% don't have wills. And we know from the passing of Aretha Franklin in August of 2018 and Prince, who died April 21st, 2016, that it's not just those who cannot afford a will that have failed to make one. Super wealthy, brilliant, meticulous, hardworking, in-control people, surrounded all day by lawyers, die without wills. If you die without a will, you don't choose what happens to your money, your hard-earned assets. The state where you reside decides based on their laws. In some states, a surviving spouse can inherit everything, even if this is the fourth marriage and the marriage was only for 18 months, and the deceased spouse had 4 adult children from her prior marriages. Is that what you want? Well, you can solve the issues by doing your own planning and putting that plan into place. In other states, the surviving spouse gets a half or a third of the estate, and the rest can go wherever the state says. Do you want your estate to be used all up in fighting in court? You have to take control over your estate and minimize arguments and disagreements among your heirs. And you do that with detailed planning and execution. A will and other estate planning tools, like we discussed last week, trusts, and even letters to heirs. All of these tools and devices make your intentions clear. Famous and wealthy singers and actors dying without a will? How does that happen? Especially when these individuals' estates often continue to generate significant revenue after their deaths. Deals are still being made. Songs and even entire albums are being released. How does an individual often work diligently over a 30, 40, 50, even 70-year lifetime, often creating intellectual property, accumulating 80, 100, $200 million estates, and then after a lifetime of hard work, fail to take the next steps and not protect her legacy by not having an estate plan that protects and preserves her wealth for her beneficiaries and heirs into the next generation? Why were her advisors not able to successfully convince or persuade her that a cultivated, coordinated estate plan was in her best interest and in the best interest for her beneficiaries? Why is it that the musician or actor, who in many cases is so meticulous in other areas of their lives, their art, their business, but not in this area? Meticulous in the clothing, meticulous in the homes. Who benefits from the artist failing to protect these assets? Who loses? This is the topic for this week on Advocacy at 8. Examples of wealthy artists passing away without a trust or will. Aretha Franklin died without a will. As we said a minute ago, she died August 16, 2018. Her estimated value of the estate, $80 million. She had 4 sons as beneficiaries, grandchildren, nieces, and nephews. A niece asked the court to appoint her as personal representative of Ms. Franklin's estate. The attorney of Ms. Franklin, who was her attorney for over 30 years, will reportedly be the attorney to assist Ms. Franklin's niece with the probate process. Reportedly, one of Ms. Franklin's sons had special needs from injuries suffered some years ago. He might have benefited from the special needs trust that we discussed last week in an earlier video. 2. Prince died without a will. He died April 21st, 2016. Many individuals claimed to be his heirs. A woman claimed to be a previously unknown wife. Individuals claimed to be his children. Others claimed to be his brothers or sisters or distant relatives. The Minnesota probate judge declared in May 2017 that Prince in fact died without a will and that his sister, Tika Nelson, and 5 half-siblings are heirs to millions of dollars he left behind. Now note that it took over a year for the probate court to decide that Prince died without a will. Courts move slowly. They are deliberate. They do not generally move fast. Court filings suggest that Prince's estate can be valued at $2 million, even as high as $3 million, depending on the value of his legacy and the unreleased recordings in his vault. But guess what? Because he did not have a will where he appointed an executor, and because he did not have trust where he appointed and selected a trustee, he does not get to decide what happens to those unreleased recordings in his vault. And even the administrator that was appointed by the court, Comerica, has moved his unreleased recordings from Minnesota to Los Angeles. Prince did not avail himself of any of the trusts that we discussed last week, or any other ones for that matter. And his state and inheritance tax, he did not work on reducing those or minimizing those. As a result, the federal and state taxing authorities, they're expected to take half of the value of his estate. If it's $100 million estate, if it's a $200 million estate, then the federal and state tax authorities are going to take $100 million.